Let's start with a little background on this case. Congress created Medicaid in 1965 to subsidize state health care for families and individuals whose income and resources are insufficient to meet the costs of necessary medical services. Just where in the Constitution is Congress granted the power to subsidize state health care for any reason? It certainly isn't the General Welfare Clause, Article 1, Section 8, Clause 1, which reads, Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. These subsidies are not for the general welfare of the United States, but for some of the people of the United States. Actually, since the subsidy was not given to the people, it's actually for the welfare of the several states. Medicaid offers states a bargain, federal funds in exchange for compliance with congressionally imposed conditions. So Congress offered states funding they are not authorized to spend in exchange for following their rules. Isn't the offering of an illegal emolument as a consideration for action not the definition of a bribe? From the Free Legal Dictionary, a bribe is the gift or promise which is accepted of some advantage as the inducement for some illegal act or omission, or of some illegal emolument as a consideration for preferring one person to another in the performance of a legal act. So this bribe starts out with submission to Congress's illegal demand to regulate a state's healthcare system. To participate in Medicaid, states must submit a plan for medical assistance satisfying over 80 conditions in Section 1396AA. If a state fails to comply substantially with any condition, the Secretary of Health and Human Services may withhold federal funding under Section 1396C. Now, states have a laundry list of conditions they must comply with in order to be offered the bribe from Congress. And if a state doesn't comply to the HHS Secretary's satisfaction, they lose their bribe. This case involves the Any Qualified Provider provision in Section 1396AA23A, which requires states to ensure that any individual eligible for medical assistance may obtain it from any provider qualified to perform the service who undertakes to provide it. The provision does not define qualified, leaving that to states' traditional authority over health and safety matters. The law states that any individual eligible for medical assistance can get it from any provider qualified to perform the service. However, the law doesn't define qualified, leaving that up to the states. More on that in a minute. The question is whether individual Medicaid beneficiaries may sue state officials under 42 U.S.C. Section 1983 for failing to comply with the Any Qualified Provider provision. While the question before the court is, can individual beneficiaries sue, there's a lot more to this case.